Exactly an hour.
1 hour. Okay. So, I'm Don Ferenz. I'm the facilitator, which is great because I know very little about the topic. All I know about media is, I was told as a child, don't believe everything you read in the paper. But I do believe everything I read in WikiLeaks, especially what they said about the Chilcot Commission inquiry already being fixed even before it started. Maybe some of you read that. Anyway, it's my pleasure to let the panelists introduce themselves. We've got Ella McPherson, and she will say what she wants to say about herself. We've got Nirma Jelicic.
Well done.
Absolutely. Well done. She's well done. I knew she was well done. And I'm well done. And I'll let them say what they want to about themselves, and I'll get out of the way.
Thank you. I'm really glad to be here today. It's been fascinating so far, and we're only sort of 1/8 of the way into it. I'm Ella McPherson. I'm in the Department of Sociology at Cambridge. And I'm currently researching social media and human rights and how it changes how human rights are reported and who gets to speak on human rights issues. And, key to human rights reporting is this idea of evidence, right? Whether you're thinking about human rights reporting in terms of advocacy or in terms of courts. What social media has done one of the things it has done is introduce new channels of evidence. Potential evidence, I should say. So what I'm going to do right now, just to kind of illustrate this point, and to get at what I want to talk about today, which is what I call the verification problem, I'm going to give you 3 stills from YouTube videos, which are all have been kind of caught up in discussions around, human rights discussions around whatever happens behind these videos. So I'll just show you quickly, because of course, anytime you're showing this kind of footage, it is graphic, and anyway, this is about human rights violations. So anyway, this is it's horrifying footage of the aftermath of the 2013 chemical attacks in Ghouta, Syria. That came out after the attacks, and there was a big controversy. You probably heard of it, which is that Russia's foreign ministry claimed that these videos were fake, that they were propaganda created by the Syrian rebels, and this was because the timestamp on these YouTube videos was from the day before the attacks. But this was without understanding that timestamps on YouTube videos come from whatever time it was in California at the time of upload, not the time of the actual video itself. Then the next one we have here, again, maybe you heard of this. This is footage from a video that appeared all of a sudden on YouTube and then went viral last November, and it was called Syrian hero boy rescues girl in shootout. And there's this little boy, and he's running and dodging what looks like sniper fire, and he falls down, he gets back up. He goes and he grabs this girl who's hiding behind a car and drags her basically off scene. It was, shared by activists, viewed millions of times, even covered by some mainstream news outlets, and then the BBC uncovered its cinematic origins. This video was a movie shot as an experiment by a Norwegian director using funding from the Norwegian Film Institute and Arts Council Norway. And it was shot in Malta on a set used in blockbuster films Troy and Gladiator, using professional child actors and Syrian refugees to provide the running commentary. And then they just released it on YouTube basically to see what happens, right? This is a video of a man who's shackled to a post or a tree being water cannoned by other men in uniform. And that one looks real enough in the video, but the human rights NGO Witness did a little piece on this. We can't say for sure, because in 2014, it circulated at least 3 different times with 3 different sort of framings on YouTube, so like in terms of what people were describing it as being. It was said it was in Venezuela, described as armed forces attacking a student. It was said it was in Colombia, described as Colombian Special Forces water cannoning a farmer who had taken part in an agrarian protest. And it was said it was in Mexico, and that it was police versus a member of a civil defense group. So what these videos do is show us both the pluralism potential of digital human rights reporting from civilian witnesses, so we can gain evidence that we would never have previously had from people we'd never previously have heard from, especially in close contexts like Syria. But they also demonstrate the great problem of this information, that of verification. And the fact is that human rights organizations if they can't verify a piece of information, they can't use it for evidence. Okay? And if we're concerned with pluralism and equality of access to professional mechanisms of human rights and transitional justice, verification then becomes a problem. It becomes a bottleneck. Okay. So this is I'm researching this sort of as we speak. So I'm sort of struggling with how to conceptualize how this problem works. And this is, I won't go too much into this because it starts to get a bit theoretical in terms of Bourdieu. But what I do is use Bourdieu's concept of the field to try to plot out how this information moves. So here on the left, you have the field of human rights fact-finding. And this is, the NGOs, for example, are in this field. This is professional fact-finders who are trained and who sort of know each other and work together, etc. And it's useful to think about this in terms of fields because fields have particular forms of capital. So, for example, we can think of this field of having cultural capital, the knowledge around fact-finding methodology, including social media verification. There's a lot of trainings, for example, going on right now in this field in terms of how to process this information. We also can think of fields as being characterized by logics, which are kind of like the rules of the game. So again, this field with respect to information has a logic. And of all the sort of characteristics being looked for in information, a very important one is veracity, which is why verification, kind of the norms and practices of verification, is core to the logic of this field. It's not just because you need it to make good evidence, but you also need to have credible evidence to maintain your reputation as a credible organization, which is, again, fundamental to the work of human rights organizations. So that's the field. And part of the reason why I like to talk about it as a field is that we can think about civilian witnesses as being kind of in a non-field, which is that thing to the right. If that makes sense. And it's not, I'm not saying that all civilian witnesses are in a non-field, because, for example, you have at this end activists who are sort of networked with NGOs and sort of, they know how to process information, etc. But at that end, you have the accidental civilian witness, and these are people who happen to have a smartphone, a social media account, and they're in the words of I think a journalist who's speaking about it, they're in the wrong place at the wrong time, and they document it, and they want to share it, right? They want to witness, they want something to happen as a result. The problem is, sort of, how this helps us think about verification, is that the people on the right do not have the cultural capital, they do not have the knowledge to know that these people need verifiable information. And even if they do know that, they don't know what they're looking for, right? Because they've never thought about this in this way before. They also do not have the networks to know how to get this information into that field. And as become apparent, it's also they have problems in terms of their own reputations, their own sort of wealth of public credibility. I'll explain that in a sec. But first, I'm going to just explain a bit about verification, how it works in the social media space. So verification in the social media space is still based on the same fundamentals as verification before the social media space, which is that anytime you get information on a human rights violation, you have to identify the content and the metadata, the source, the time, the place of production. And you do this by cross-referencing the information you've gotten with other methods and other sources. So that hasn't changed, but the tools that we have to do this have changed, as has the content. So I'm just going to run you through a couple of quick examples before getting back to this problem. So for the source, right? To get at the source of this information, one of the things you have to do is establish chain of custody back to the original source. Especially given that on YouTube it's very common to scrape, so to republish information originally published by someone else without attribution. And there's these reverse image search engines like Tonight that let you do this. But then you need to check out the source. Once you get to it, you need to know about the source. What are their motivations? What's their identity? What are their affiliations? Where might bias be coming from? Etc. And you can do this via digital footprints. So I did it to myself using People, which is one of these kind of, it goes into what's called the deep web, which is all these databases online that aren't searchable via Google, but are things like court records, publication records, kind of databases related to eBay and Amazon and Twitter and even dating websites, right? So you can put in anyone, you get all kinds of information about them. So here what I just want to show you is that I think I put in my Twitter handle. And some of it's not quite right, like I'm not 72 from Illinois and Idaho. But then some of it is very right? So this was further down. My age, my hometown, where I've lived, that's my mother, my father, my brother, right? Spot on, okay? So that's one way of looking for people and their backgrounds. Then another way is this. You guys know what this is? No? Yes?
Verified.
Yeah, if this is a blue verification icon on Twitter, okay, which goes next to your name and is an indication that Twitter's checked you out and says that you are who you say you are. Okay? So I actually got this from a website that teaches you how to fake that, but anyway, that's what it is. So another, so then you move on from source, you know who I am, whatever. You need to know about whether what I'm saying happened when and where I said, and not like that water cannoning video that was kind of repurposed in all these different places, right? So you can look at all kinds of things like the embedded data in an image. You can ask the source. You can look for indications in the content, and cross-reference that with other databases like Google Street Maps. And this is an amazing example of what Elliot Higgins, who is one of the experts in this field of really, really kind of cutting-edge stuff, what he calls magic, because it looks like magic. Okay, so he and his organization Bellingcat are tracking the transit of Russian missiles into Ukraine by following images on social media. And I think they were made aware of this tweet, right? And in this are these what are they called? Latitude. Yes, thank you. Coordinates, latitude and longitude. So he was able to then go into Google Maps and put those in, and looked at little things in the image and found the same on Google Maps. So he said, there's a highway marker in the picture. Yes, I found that on Google Street Maps. There's a telephone pole. I found that. But those are pretty common things, he says. Then he went and looked at the ground under the tank, and he found a crack in the road, which he then matched to a crack in the road that he saw on Google Street Maps. Led him to believe that actually this is where the person said it was, right? So that's just this little sort of snapshot of how this process works. You can see it can be very time intensive. And that's going to get us back to this problem of the verification barrier, okay? So you can see, just from what I've been saying, that verification and pluralism are in tension, especially because there's a limited amount of time to process this information. Not everyone's human rights information becomes evidence. Not everyone who's going on social media and documenting or denouncing a violation then gets access to the institutional mechanisms of human rights and transitional justice. And the thing is, and the key point here is that it's unequal in terms of who can get their information from there into that field, into the fact-finding field. Like I said, civilian witnesses with cultural capital about verification know how to embed metadata and can make their information easier to verify. Civilian witnesses with symbolic capital in the form of well-established and networked digital footprints make it easier for fact-finders to identify and evaluate the source and therefore make their information easier to verify. Like, I bet if I documented something, they went on people, they saw Cambridge, they would believe me, right? At least more likely to believe me than a random person with no affiliations. Let me just get back to that blue badge. So no one really knows how the verification process works at Twitter, but they put up this nice little frequently asked questions page to kind of address some of the most common concerns they must hear. What kind of accounts get verified? Highly sought users in music, acting, fashion, government, politics, religion, journalism, media, sports, business, and other key interest areas. We do not accept requests for verification from the general public. So what that does is show you that the verified badge, which is a kind of verification shortcut, is allocated to those of us with the most financial, symbolic, political, and cultural capital, right? Getting back to the theoretical way to understand this is that we can think about the ability to get information from there to there as, after Gandhi, who has a concept of information subsidies, a kind of verification subsidy. namely strategies that can make my information easier for you to use. And Gandhi has this economic metaphor of information subsidies, which I think is so useful because it connects for us how the ability to provide information subsidies is correlated to your levels of capital in its various forms, right? So the caveat here, of course, is that social media information is by no means the only or the main source of evidence in human rights reporting. On-the-ground investigations, I would say, are still the gold standard. But in the context of human rights organizations' limited time and resources, a major concern for me, again after Gandhi, is that it's those who can best provide verification subsidies who may be most likely to gain access to the human rights mechanism if time is of an issue, right? And actually, it's often those with the least resources who most need this mechanism. And I'm going to end on a development in this area, which I'm finding very interesting, which is this kind of thing, which I call a third-party verification subsidy. And I'm normally quite skeptical of sort of technological solutions to human problems, especially problems about inequality, but I wonder if this might be a step in that direction. These are apps. They're called what Sam Gregory of Witness calls Eyewitness Apps or platforms. And basically what they do is you can go into it and then it automatically embeds all of this metadata, makes your information really rich and easy to verify. And it also takes away the need for you to have a strong digital footprint because it can say, instead of saying this is from this person, it can say this is from this phone and it has not been tampered with. Okay, so I think there's promise here for dealing with the kind of pluralism and verification tension in these new technologies. That's it.
Thank you. Wonderful. Okay. I think what Judith. Yeah. Well, they want to keep it up. Okay, so Nirma, you're on till 4:50.
Oh, lovely. Yes.
You can see the clock.
I can speak from here? Because I don't have a presentation, so, okay. Hi, everyone. Thank you so much for giving me this opportunity. Thanks to the organizers for bringing me all the way from lovely Brussels and giving me the opportunity to visit Oxford once again. We all have biographies in the sheet, so I won't do as Don said and introduce myself fully, but I will just touch upon what I do at the moment. I work for a new organization called Commission for International Justice and Accountability, which is made up of what I would call, or we call ourselves, self-exiled individuals from international criminal tribunals existing and ones that are winding down already. And the idea that we are trying to pull through is that of building up criminal cases against highly ranked leadership figures in the conflict in Syria on the basis of material documentation and insider evidence produced by the parties to the conflict. But I will not be talking about that as much during this presentation. I will, if I get a chance in the 15 minutes, touch upon why we don't focus and don't look into the stories and evidence collected by journalists and media organizations as a separate entity in Syria, and what kind of evidence we focus on in building those cases. Suffice to say that we completed first of these 3 cases focusing on and applying the standards of investigations and evidence that would be applied at the ICC in order to make these cases admissible. But before I was doing this, I was working at the ICTY, the first ad hoc tribunal, as you know, it was set up in '93 as an answer to the ongoing conflict in the former Yugoslavia. And that's where I want to start, actually. You were speaking about the future and the new age technology, and I want to take us back almost a quarter of a century, which is when the role of the media started changing, and the questions of the role journalists play and could play in the wider transitional justice area, and especially in the criminal justice area, how that impacts the profession of journalists. I did work as a journalist, as by the way, in the UK in the 90s and up until 2003 when I moved back to the former Yugoslavia where I come from and started a media development organization. So it was, I was reminded today by an article that a friend of mine who's a photojournalist from conflict zones, Ron Haviv, appeared in all places in South Africa. Ron Haviv is a guy who in April 92 entered the city of Bijeljina with the paramilitary troops of known as Arkan's Tigers, and continued to take photos of these paramilitary troops going through this predominantly Muslim town, burning the mosques and taking out obviously civilians, individuals out on the street and basically beating them up and then executing them. One of those images, or actually two of them, became most famous ones from the conflict in Bosnia. One of a man kneeling down on the street praying for his life, and then consecutive line of photographs as he drops dead because the paramilitary just shot him. And then the second one, of course, where the wife and the sister-in-law of the said man who came to help him were also shot by the same paramilitaries. But what was missing at that time, and at this time there was no international tribunal in existence, remember, what was missing at that time was, obviously he had in the frame and on his film, because there was no digital camera then yet, photographs of the crime taking place. These people were dead, but he didn't have the picture of the people who were committing the crime. And as if by order, one of the soldiers came nonchalantly with his sunglasses perched on top of his head, white sunglasses, and a cigarette in one hand, automatic gun in a rifle on another, and kicked the body of the dead woman. And there was his final frame. All of these images ended up being used in consecutive trials in the ICTY many years later, because Arkan, who was the leader of these paramilitaries, was indicted by the ICTY but never was apprehended or put on trial due to the fact that he was killed in a lobby of a hotel in Belgrade due to some other dodgy connections with organized crime, as you often find them between war crimes and organized crime fields. So Ron Haviv never appeared to testify, but his photographs were used as evidence in some of the trials. A few months later, that same year, so we're still in 92, and there's still no digital media, there's still no trial, there's still no tribunal, let alone trial. A few months later, in August 92, a bunch of British journalists, actually one TV crew and one newspaper, managed after weeks of pestering to gain access to what were rumored to be detention camps for the civilian population in northwestern Bosnia, so completely other part. ITN and The Guardian, Penny Marshall and Ed Valnami were the journalists, entered into 2 camps on that day and proceeded to interview the detainees, who obviously couldn't tell them much because they were very afraid, but also the images that they took spoke much more than the detainees could. And one of the images that again ended up symbolizing the war in Bosnia and actually moved the international community into doing something other than the intervention, which was not acceptable at the time, was the one of an emaciated man, Fikret Alic, behind the barbed wire with his ribs showing. In that August sun of 92 in Prijedor. And it is often said that these images and the reactions from the international audiences and the public, which I very often compare to the reactions that you have now to Syria, and which are considerably fewer and smaller and less audible than we had during Bosnia. These reactions are said to have pushed the international community into discussing what should be done to address all of these crimes that were being reported by the media, by the Commission of Inquiry or Commission of Experts that was set up by the UN, etc. And ICTY was established by the resolution which was unanimously voted by the Security Council, which is a rare thing, as you will know, in May 93, so a few months later. So that's the kind of the start of how the media could and did play, if you will, a positive role in recording and ending up producing the evidence for the trial and the tribunals that they never knew could exist. But fast forward a few years and the trials, the court was established and the trials had started, and the question arose about whether journalists who reported so extensively from the wars in the former Yugoslavia should testify in the trials. And this is something I will speak about. I'll try and focus on it from the media perspective, because I'm sure you will talk about it from the legal perspective, because you were at the court at the time and I was in London working as a journalist. But it was a question that divided the international media. And I think you could really geographically divide it, because the US and the American media predominantly said no, journalists should not be compelled to testify, and the British media said our duty, here is our chance to do more than be the observers and report on what was going on. Here is our chance to see our reports do something else. Here is our chance to see our reports put bad guys behind the bars. And it was a continuation of something of a debate that was going on still during the conflict in London. I remember speaking with Martin Bell, whom you will all, or maybe some of you won't remember, from the BBC, because some of you are younger, I suppose. He's retired, right? But he was a BBC war correspondent, and he was very often accused of being. The term that was coined was journalism of attachment. How do you report either calling into question the objectivity of the reports, whether before you testified in the tribunal, but also after you testified in the tribunal? And it was a debate that continued well into this question of whether the media or the journalists should be compelled to testify. A very good friend of mine, who happens to be Ed Valjani, the guy who entered into Amarska in August 92, is what I call a serial witness. I think he's testified in 7 or 8 cases in The Hague by now, and to the detriment of himself and his career sometimes. But he was very vocal in the duty of the journalist to testify, not only to allow his stories to tell, to inform the trials, but also to sit on a witness stand and expose himself to the cross-examination, but also open his notebook for the scrutinization of either side to the proceedings, whether it's the office of the prosecutor or the defense. And this is where the key questions, as those of you who study in media, arise. This is why the question of what happens with the reports that I do, and what happens with all the notes and all the knowledge and all the sources that informed my story is different. In principle, ICTY ruled on this matter in 2 trials, I think, right? And you will talk about that, so I will not touch upon it. But I think the issue is still open and has been brought up again in the cases of Charles Taylor in front of the Special Court for Sierra Leone, and will probably be raised again and again in front of ICC as the cases, touch would, come there, but they're not coming yet. So that's one issue that I wanted to raise and open up for discussion, and that's the role of the international media. But I think something we have to differentiate, and what came out from the first panel is how the national media play, what is the role the national media play in the conflict, in documenting the crimes and exposing those crimes. And I will leave the Yugoslav example behind, because I think a lot has been written about it, and I'm sure all of you have read both about Yugoslav media and Rwanda media and the role they played into advancing the nationalism and division, and even sometimes the crimes that were committed in these countries. But would like to. I was last week in Ukraine working with investigative journalists and something that is a new term in the media world, and it's called the media activists. And I don't quite understand that term because I was brought up and trained by very old-fashioned journalists, and I'm not sure that you can be a journalist and an activist at the same time and retain your objectivity and impartiality and everything else. But there you go. So there are old-school investigative journalists sitting with me in Ukraine and the media activists from the new media outlets and media organizations that are mushrooming up in Ukraine, post-Yanukovych ouster, and we're talking not only about the reporting on what is going on in the regime change in Ukraine, but also what is going on in the Eastern Front. And the questions keep on coming to me about the crimes that these journalists, who are really, really young and keep on going to the conflict zone without any protection behind them, and they say, you know, I report on what the separatists are doing, or the pro-Russians, etc., but I see more and more what our guys are doing, be it the military structures or the volunteer guards that have also been established in the Eastern Front. But we choose not to write about it, and they ask me, you know, what would you do? Because we have all this. We have the information, we have the statements, sometimes we have the pictures and the images, but we feel if we write about it, it will demoralize the volunteers, it will demoralize the soldiers, it will demoralize the population, which is already, going through the series of revolutions and uprising, and now the annexation of the part of the land, etc., etc. So they self-censor. Unlike the media in the Balkans, where those who wanted to report on the crimes from their own side were often prevented by their editors or publishers from doing so, bar a few examples. These ones are choosing themselves not to publish it and to keep it for the day when it might not damage the society as it could now. So, I mean, of course I told them I would publish when they asked, but again, these are the questions that the national media ask themselves. So, with Syria, I think in Syria I want to use, and that's my third example, and I'll try to make it quick because I'm already on 15 minutes. What has happened in Syria, and I see happening in Ukraine, is you have the international community which is trying to learn what was missing in the conflicts 20 years ago, and what we didn't, in quotation marks, what we didn't do right in Yugoslavia or in Rwanda, and let's try and rectify it. So one of the things that people now realize that they have forgotten always in terms of ongoing conflict or later dealing with the past processes is you need to focus on the media, as we heard in the introductory remarks. Another one is when you get to the international criminal justice or even national judicial processes, the outreach is the word du jour. And everyone talks about it, but somehow I keep on seeing it completely misapplied and not having the effect that it should be having as we imagined it previously. So what you have in Syria is, or around Syria rather, is the same as in Ukraine, and you have mushrooming organizations, some of them under the media title, some of them under newspaper title, radio title, some of them under just general NGO title, that the international community in the first years of the war established and or helped establish and fund and train to act as documenters and collectors of evidence of human rights violations, but also violations of international criminal and humanitarian law. And what happened, because now we are in the 5th year of the conflict, is that it's good. The more people you have, documenting, the better it is for the later process, because you have more information to establish the wider truth. But the question is, and the problem that I have, is that expectations of all these people have been raised above all that is reasonable, that everything they do is going to be admissible and used one day in a trial in ICC or some other court. And it isn't. Majority of the stuff that they have collected, majority of the things that you find on the YouTube is not going to be a usable, admissible evidence in the International Court of Law. It doesn't make it useless to the wider transitional justice process, but when you say, or when I speak to them in the comments, they say, don't focus on it specifically thinking one day I will be sitting in a court and explain how I got this video, and then I will be vindicated somehow. Collect it for the wider good of the society, but they already get angry and disappointed at the very suggestion that not everything will be part of a litigation in a court of law, which I see long way from today's date becoming a real problem, not only for the wider society, but for these people who are already getting a bit fatigued by the conflict that is being ongoing and has no end in sight. And very often they are young people, they are activists, they don't come from the investigative or law enforcement backgrounds, and they expose themselves to the dangers, and indeed very many of them get wounded or indeed killed in order to obtain something that they don't know is not going to be utilized in the way that they hope it will. And that's then the third question that I would like to ask, and it is, how much damage are we introducing for the future of a society by, in a way, and maybe I sound too cynical here, but we are focusing on this collecting evidence and criminal investigations by so many different organizations in order, from the international community perspective, in my opinion, in order to limit the accusations of standing idly by while the conflict goes on. But obviously, this, while good, and yes, in the future it will have some kind of a use, is not going to replace the actual intervention, be it political, military, or diplomatic, that should be taking place. So, sorry, I took a bit longer.
No, that's okay, because I know that Graham had to rate his talk, so I gave you a little extra time. Thank you. Okay.
Thank you. Thank you, Norma, for the very befitting introduction to what I'm going to talk about, and for the excellent work you did at the ICTY. I'm the token lawyer on this planet, on this panel, not on this planet. Rather inflated ego, if you say, on this planet. So I'm going to speak about evidence, and what is it that we look for as prosecutors, as defense lawyers, as judges. And I think what Norma said was very befitting, to really speak about the difference between information and evidence, and the two are not the same thing. So I want to begin by situating this discussion for the purposes of this panel in terms of the notion of journalistic preference. Privilege. I've not slept much last night, I'm sorry. Journalistic privilege, or what is known in English law as legal professional privilege. When should the profession of a particular potential witness, in this particular case a journalist, have privilege against testimony in light of the public interest with respect to that particular profession not somehow being compromised? And of course, the notion of journalistic privilege is very well recognized in domestic legal systems. Some of you may recall the famous case of Judith Miller recently in the United States, who refused to testify concerning a CIA leak which related back to the weapons of mass destruction debacle prior to the invasion of Iraq. And she was held in contempt of court and served prison time as a journalist, and she was willing to serve the prison time instead of compromising her anonymous source. And the worst part of the punishment is that she went from being a New York Times correspondent to a Fox News analyst, but that's a discussion for another time. So the difference between information and evidence is really a question of quality. And with the prevalence of media activists, citizen journalism, and I think your presentation really set up this discussion very well, the amount of information that's available now, as opposed to even 1993 when the ICTY began its operations, has really proliferated on an exponential scale. And a big part of the problem is obviously sifting through that information to see what is credible and what is not. But there's a very big difference between trying to determine what is credible from the point of view of journalistic integrity, from the point of view of policy formulation, as opposed to gathering evidence. And although sometimes institutions such as the ICC have tried to follow the headlines to prepare indictments in real time to try and somehow impact the situation on the ground, the criminal justice system is slow. It is a slow, cumbersome, and costly procedure, and very often it will be many months, if not many years, after the crimes have occurred when an accused is finally arrested and when the witnesses will be scrutinized in some sort of a criminal procedure. So information from the criminal investigative and prosecutorial point of view is relevant as a way of finding leads. And the typical situation, as you have, whether with respect to Bosnia or Rwanda or Darfur, is that there is typically a massive crime base. There are many incidents which one can investigate. This is not a kind of smoking gun scenario where it's sort of O.J. Simpson putting on the glove in the courtroom, or that missing piece of DNA evidence which will conclusively prove who's responsible for a particular murder. We're typically dealing with crimes against humanity, which by definition are widespread and systematic crimes. So the relevance of evidence, as I will explain further, has to be seen in that context. So information very often provides a lead to look into this or that situation. And I'm glad that you brought up the case of Ed Villamy, who's one of the outstanding people that in the summer of 1992 first exposed the horrors of ethnic cleansing with that graphic photograph from Omarska. And the first cases before the ICTY were all from the Prijedor district where Omarska was situated. So very often journalism and the provision of information or media reports provides a lead which then mobilizes resources to conduct a proper investigation and to gather evidence that can withstand scrutiny in a judicial procedure. Now, evidence in the context of criminal law has to be understood in light of the burden of proof. In common law systems, the burden of proof in a criminal trial is beyond a reasonable doubt. In the French system, it's called intimate conviction of the judge, but for the most part, criminal trials have the highest possible burden of proof compared to, let's say, civil trials. So it's not sufficient simply to establish a prima facie or sort of whiff of suspicion test. And very often when we were doing our work in the ICTY or the ICTR for that matter, or other cases I've been involved in, people will say, well, it's very obvious that these people are guilty, so what is taking you so long? And it's a very different question to transform what is available in the form of media reports into evidence, because one of the fundamental rights of the defendant is to challenge that evidence. And a skilled lawyer, especially in the context of adversarial system, which recognizes the right of cross-examination, which incidentally does not apply to continental systems, a good skilled lawyer can do a very convincing job of impugning the credibility of even the most persuasive witnesses. So it's against that burden of proof and that qualitative requirement that one has to sift through mountains of leads in order then to find which are the most credible witnesses, how the testimony of different witnesses relates to each other. Does one corroborate the other? Are there inconsistencies? There is a tremendous amount of meticulous work that goes into preparing a case that will establish guilt beyond a reasonable doubt. And just by way of example, the Berjanin case, which I'm going to discuss briefly today, which involved Jonathan Randall, a Washington Post correspondent who invoked journalistic privilege, and that became the landmark case on journalistic privilege in the ICTY. That case went on for 284 days, so 284 court days. And the prosecution called more than 200 witnesses, and I believe the defense called just 19 witnesses. So you can see the scale of the trial and why one has to choose targets very carefully, given the fact that there are very limited resources and very limited opportunities to actually prosecute anyone. And I would even say that the ICTY and ICTR are the notable success stories if one contrasts the number of accused that were prosecuted with the ICC, which in more than a decade has not managed to even prosecute a handful of defendants. So the trials are costly, they are time-consuming, access to evidence involves all sorts of security risks, all sorts of very difficult judgment calls of trying even to understand the credibility of a witness who's speaking Kenya, Rwanda, who's speaking Arabic, who's speaking Swahili. And on top of that, hoping that one day you will actually have a defendant in the dock who will have to answer to the evidence that you've gathered. Now, unlike common law systems, which have very hyper-technical rules on admissibility of evidence, the international criminal tribunals have actually very few rules on evidence, and they follow the continental European model, which is called the free appreciation of evidence. Because you don't have a trial by jury that's susceptible to being, deceived one way or the other, professional judges are deemed to have the ability to better understand what has probative value and what does not have probative value. So short of a confession that's extracted by torture or those questions of admissibility, all evidence is admissible before an international criminal tribunal. But of course, not all evidence is equally probative, and witness testimony tends to be crucial in almost every case that I can imagine, although forensic evidence, documentary evidence, and other forms of evidence can also be, of course, very important. Now, what type of issues could raise questions of journalistic privilege? I want to go back to this idea that when we're dealing with mass crimes, typically there's no smoking gun. And it's interesting that, on balance, it's easier to prosecute the big fish than it is to prosecute the small fish. And that's one of the paradoxes of criminal trials. When Duško Tadić became the unwitting and unlikely first defendant before the ICTY, it so happened that the war was raging in the former Yugoslavia. There was no prospect of having a single defendant. We were even thinking about placing ads in the newspapers, wanted war crimes defendant. And it so happens that Duško Tadić was in Munich, and he was identified by some refugees from the former Yugoslavia, and he became the unlikely first historic trial before the ICTY. Now, what is the problem with prosecuting a small fish like Duško Tadić, who was basically a local thug that would come into the camps, including Omarska, from time to time, just to entertain himself with his friends? The problem is that the range of evidence that is relevant to implicating him is actually quite limited. Given the fact that he was not in a position of command or control, you need to find witnesses that can specifically place him in specific locations in relation to specific crimes at specific times. Whereas someone who's in a position of command, and I'm not speaking here about command responsibility as a doctrine, but the attribution of liability to those who have positions of military or political authority, given that the crime base is extensive, tends to be easier because what you have is a case of circumstantial inference of criminal liability. And the typical defenses which are available to military commanders or political leaders relate either to knowledge of the crimes, whether they were put on actual or constructive notice of the fact that crimes were occurring, or questions of command and control, whether they had de facto control of those that were responsible for the crimes, or whether they were simply in a position of token leadership. So the crime base itself is less of a problem, typically, than the question of attributing liability to a particular defendant. And attribution of liability is typically a separate question than the crime base. The problem, once again, when it comes to journalists, is how crucial, given the context that I've provided, is the testimony of a journalist. Now, the idea of privilege, as I explained, is commonly accepted in all legal systems. By way of contrast, I want to speak about the two leading cases in the ICTY which dealt with the question of privilege. One of them, the Simic case, dealt with the privilege of the International Committee of the Red Cross, and the Berjanin case, as I mentioned, related to journalistic privilege. And I think that both of these cases are very instructive in explaining what I think have been the mistakes that have been made in the ICTY in being a bit too trigger happy in the prosecutor's office in calling this or that witness when it is not absolutely crucial to do so. And that, in simple terms, is the circumstance when journalistic privilege will not be upheld by the court, where the testimony or other information at the disposal of a journalist will be crucial to determining a question of guilt or innocence. We have to bear in mind that it's not just a question of guilt, it can also be a question of innocence. So the case of the ICRC in the Simic case, Simic was also dealing with Priodor, I believe. Mm-hmm. So many of these cases, Berjanin was also in Priodor, so many of these cases dealt with the situation which Norma referred to earlier. In the Simic case, a former employee of the ICRC was called to testify as a prosecution witness. And he agreed, actually, to testify. There was no need to compel him, unlike Jonathan Randall, against whom a subpoena was issued by the trial chamber. But the ICRC invoked its privilege despite the fact that its former employee was willing voluntarily to testify. And of course, the ICRC's concern is the precedent that such testimony would establish in terms of compromising the strict neutrality which it observes in the field. In that particular case, the ICRC intervened, invoked its privilege, and the trial chamber gave the ICRC absolute privilege, not qualified privilege, which applies most often, but absolute privilege. And I believe that the fact that the prosecution was not very cautious about whether it was necessary to call the ICRC, I think resulted in the court going to the other extreme of giving absolute privilege, which I think is problematic, even in relation to the ICRC. It's interesting that among the 3 judges in that trial chamber, the majority, 2 judges, believe that under the Geneva Conventions, the ICRC should have absolute privilege. We need to say you can never compel the testimony of an existing or former ICRC employee under any circumstances. That is entirely at the discretion of the ICRC to make that decision. Whereas Judge Hunt, the Australian judge in that trial chamber, wrote a concurring opinion which agreed that in that particular case, privilege should apply, but that, like other forms of privilege, there should always be a balancing of interests. One interest being not to compromise the neutrality of the ICRC, but the other interest being the effective administration of criminal justice. And it's interesting that under Rule 97 of the ICC Rules of Procedure and Evidence, the ICRC now has absolute privilege before the ICC as well, and it's now actually been incorporated in the ICC Rules of Procedure. And those of you that are familiar with the history of the ICRC, in particular in relation to the Holocaust and the question of what did the ICRC know that it did not divulge, and whether not disclosing that information was justified in view of what little assistance actually was administered by the ICRC in many of the concentration camps, that is a whole other debate. But in relation to journalistic privilege, there is only a qualified privilege and not an absolute privilege. In Berjanin, Jonathan Randall, a dear friend of mine, one of those that was in the former Yugoslavia very early on in the conflict, and who was a man of extraordinary energy. I don't know how old is Jonathan now. He must be in his 80s.
80s, he was in his 50s then.
Yes, but he was a man that was rumored to have slept on occasion, but I never believed those rumors. But he was a man of extraordinary energy that crisscrossed the former Yugoslavia and managed to conduct the most extraordinary interviews under very perilous circumstances. And that made him, of course, a very attractive witness. And in the case of Berjanin, who was a quite significant figure in the Prijedor region of Bosnia, Jonathan had written a story in the Washington Post which referred to some highly incriminating statements made by Berjanin, where he openly spoke about ethnic cleansing. He basically said that, we have to expel all of the non-Serbs, and people are free to leave if they want to leave. If not, we will force them to leave. And it was one of those very compelling statements. And when Jonathan Randall refused to testify, and his testimony was merely to confirm the story that had already been published, so there was no question of disclosing the identity of anonymous witnesses. It was merely a question of him appearing in court to lend credence to a story that was already in the public domain. And the trial chamber issued a subpoena. Jonathan Randall appeared only to invoke privilege. The trial chamber held that he could not invoke the privilege because the material was already in the public domain. There was then an interlocutory appeal to the appeals chamber, and in 2002 the appeals chamber of the ICTY upheld his privilege. And the reasoning is interesting, and maybe I'll just speak a bit about the reasoning before ending my comments. The trial chamber's reasoning was that privilege may be relevant where you have anonymous sources, for example, that you don't want to compromise, but where you're merely asked to testify to verify a story that is already in the public domain, then there is no logic to invoking journalistic privilege. The appeals chamber had a very different reasoning in upholding the privilege of Jonathan Randall. First, the appeals chamber recognized that there is a public interest in not compromising, in effect, the neutrality of journalists, exactly what you were referring to allow them to conduct interviews without creating a situation where anything that is divulged to them could potentially be used against the person granting the interview in judicial proceedings. The appeals chamber, however, narrowed the notion of journalistic privilege to what I would call the privilege of war correspondents. And the court made a distinction between journalists in general and war correspondents in particular, given the specific circumstances that they face in trying to cover armed conflicts. Second, the appeals chamber held that in this particular case, the testimony of Jonathan Randall was by no means crucial, and it was not sufficient, as the trial chamber had held, that his testimony was merely pertinent. That was the standard the trial chamber had espoused. That the standard of pertinence was substituted by the standard that the testimony must be crucial and must not be available through any other means. So a much more stringent test. And on that ground, the privilege of Jonathan Randall was upheld. So just by way of summary, I'm more, I believe, on the journalist's side here, even though I'm the lawyer on the panel. And I know that we're supposed to have a debate here, but I actually think that the prosecutor's office has, on more than one occasion, made the mistake of what I call sort of cowboy investigative techniques, where one calls witnesses without actually considering carefully how those witnesses could be compromised in the discharge of their work, whether it's the ICRC, whether it's a journalist, humanitarian workers, and very often it's the star quality of a witness, such as Jonathan Randall,